Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuwajibishe, tuimarike. Umoja wetu ni nguzo yetu, tuinume jumuiya yetu.
Good afternoon. We're going to give a joint statement of Africa civil society organizations, human rights defenders, and bar associations on the abduction of Council Arias Lukwago and the escalating assault on the right to fair trial in Uganda.
Today, June 17, 2026, illegal detention barracks are not courts. African civil society condemns the enforced disappearance of Council Arias Lukwago and the militarization of justice in Uganda. On the morning of June 15, 2026, one of the lead lawyers of Uganda's opposition leader, Dr. Kizza Besigye, Ssalongo Arias Lukwago, sounded an alarm on social media that his home was being surrounded by the military. A few moments later, military officers scaled his perimeter wall, forced their way into his residence, and violently took him away in a numberless Toyota Hiace vehicle, commonly referred to as a drone, and the infamous safe abductions of Ugandan government critics, real and perceived. Ssalongo Arias Lukwago, also known as the Road Mayor, having served as the immediate former mayor of Kampala City, was driven to undisclosed location. A few hours after his abduction, President Yoweri Museveni's son and the commander of the military, General Muhoozi Kainerugaba, started releasing disturbing photos of him. General Muhoozi Kainerugaba boasted of having captured the fool and humiliated him publicly, claiming that he was urinating and needs diapers. This is a gross violation of Uganda's laws and its obligations under international and regional human rights laws. While some media houses reported it as an arrest, Ssalongo Arias Lukwago was not arrested by the institution mandated to carry out arrests. No arrest warrant was produced, no summons were served, no charges were preferred, and he is not being held in any gazetted detention center. Council Lukwago, a distinguished advocate, leader, and senior opposition figure, was discharging his professional duties as the lawyer of Dr. Kizza Besigye and his co-accused Obedi Lutale, who abducted from Nairobi in November 2024 and illegally extradited to Uganda. The duo has been in prison since then, with their bail applications unreasonably denied more than 10 times. While Muhoozi Kainerugaba has threatened to behead and hang Dr. Besigye, Lukwago was preparing to serve process in the human rights suit concerning the abduction and the treatment of Dr. Besigye, rather than let the law take its course. Armed soldiers stormed the civilian home, forced entry, and kidnapped an officer of the court in order to intimidate, silence, and obstruct the administration of justice. The act assaults the rule of law, the independence of judiciary, and the right of every legal practitioner to work without fear, as protected under national, regional, and international human rights standards.
This abduction is not an isolated event, but a sustained campaign against the defense of Dr. Besigye, his supporters, opponents, and critics of President Museveni, and those perceived to be close to the opposition. On 10th December 2024, security personnel seized retired Major Ronald Iduli, then a member of the defense team, from his home in Bulenga at about 4 a.m. on the eve of the court appearance. On January 7th, 2025, security operatives assaulted Advocate Aaron Kiza at the General Court Martial, where he represented the accused, detained him at an undisclosed location, and summarily sentenced him to 9 months imprisonment without trial. He served 88 days before the High Court released him on bail on April 14, 2025, at an exorbitant fee. These abductions take a toll not only on the legal fraternity, but also inflict excruciating pain and torment on families and society as a whole. The systemic abduction, forced disappearance, torture, and arbitrary arrest of men do not only affect the victims, they also inflict deep psychological pain upon the nation's mothers, wives, children, grandchildren, siblings, and entire communities. The story of Sam Muhoozi remains a chilling testament of the relentless targeting of political opponents and the emotional wreckage left in its wake. A recent interview with Muhoozi's mother is harrowing to watch. She recounts the trauma of waiting over 8 years while he was arbitrarily detained without trial in a Congolese prison, only for him to be abducted again in Uganda just as he arrived to visit her for the first time in 8 years. Muhoozi had fled political persecution, but instead of asylum, the two governments connived and detained him. For a mother, a child, a sibling, or entire family to have their loved ones snatched from them, and then to see them mocked, degraded, and publicly humiliated is a form of psychological cruelty that transcends even the politics. The family's pain is compounded by not knowing where their loved ones are. In both Muhoozi and Lukwago's cases, reports have indicated that their health is of grave concern, leaving their families to grieve their loved ones who have been forcefully disappeared. The collective civil society organizations, human rights institutions, defenders, and members of the legal profession across Africa are gravely concerned about the brutal abduction, torture, and inhumane treatment of Council Arias Lukwago, an elected leader and a distinguished member of both the Uganda Law Society and the East Africa Law Society. The violence follows directly upon the service of miscellaneous application number 0227 of 2026, in which Dr. Besigye seeks the High Court's protection against Muhoozi Kainerugaba, Chief of Defense Forces of the Uganda Police Defense Forces, repeated public threats upon his life. Service of that very process appears to have provoked and disproportionate military response visited upon Council Lukwago. This morning, the same officers returned to X to mock the accused and their counsel to issue fresh threats consistent with statements already on the court record, in which he declared that Dr. Besigye would be hanged on Heroes' Day. It was a dead man walking, and would leave prison only in his coffin. That the most senior soldier of a state should threaten with death a person held in its custody and standing trial before its courts is a spectacle without honor or foundation in law. The family relationship between the president and his son, who is the tormentor in this case, further throws the principle of fair trial into grave jeopardy.
This is not the first time that Muhoozi Kainerugaba has openly associated himself with unlawful detention, humiliation, and torture. In May 2025, public reports indicated that Muhoozi Kainerugaba claimed on social media to be holding Eddie Muitwe, also known as Eddie Sesebufu, the chief bodyguard of opposition leader Robert Kyagulanyi Ssentamu, popularly known as Bobby Wine. In his basement, Muitwe was later produced in court, visibly weak and showing apparent signs of torture, with Uganda's own justice minister publicly acknowledging signs of torture and abuse. This pattern demonstrates not only the conduct of a rogue military actor, but a deeper crisis of command, responsibility, civilian oversight, and a presidential accountability in Uganda. These events compound a wider denial of the accused person's liberty and fair trial rights. The High Court has declined Dr. Besigye's applications for bail on 4 applications. His 5th application awaits a hearing date, while numerous other applications have been ignored. The prosecution's delayed disclosure has stalled the trial, all while serving, and the Army General publicly announced his guilt and decreed a predetermined fatal outcome. Taken together, these events increasingly suggest that the case against Dr. Kizza Besigye and his accused bears the hallmarks of a fabricated, trumped-up, and politically motivated charge, sustained not by credible legal process, but by abduction, ambush, intimidation, delayed disclosure, repeated denial of liberty, and public threats from the highest levels of the military. These acts offend the supreme law of Uganda. The abduction of Counsel Lukwago violates Article 23, which protects personal liberty, including the right to be told the grounds of arrest and to be produced in court within 48 hours. Article 24, which protects freedom from cruel, inhuman, and degrading treatment, and Article 44A and C, which render the freedom from torture and the right to a fair hearing non-derogable. The threats of the Chief of Defense Forces offend Article 22, which protects the right to life and prohibits extrajudicial killing. Article 28, which guarantees a fair hearing and the presumption of innocence, and Article 28, which protects the independence of the judiciary. These acts equally breach the obligations Uganda has freely assumed under international law. Arbitrary and incommunicado detention offends Article 9 and 14 of the International Convention on Civil and Political Rights, and Articles 6 and 7 of the African Charter on Human and People's Rights, to both of which Uganda is a state party, as well as the universal prohibition of enforced disappearance. Threats by a state official to kill a person in custody implicate the Article of the Covenant and Article 4 of the Charter, which protect the right to life. The abduction of counsel for discharging his duty further offends the United Nations basic principles on the roles of lawyers and assaults the right of every accused person to a defense, the independence of the bar, and the authority of the courts.
Accordingly, we demand the immediate and unconditional release of Counsel Elias Lukwago and other political prisoners such as Sam Mugumya, and that they should be brought in competent courts that Article 23, Section 4 of the Constitution allows from the time of their military abductions. The immediate cessation by the CDF of all threats, mockery, and intimidation directed at their choosing and their counsel, and that President Yoweri Museveni, as head of state and commander-in-chief, immediately restrain his son Muhoozi Kainerugaba and end the impunity that has enabled him to act as a rogue military actor, publicly associate himself with unlawful detention and torture, issue unlawful threats, intimidate civilians and officers of the court, and undermine the rule of law, civilian authority, judicial independence, and constitutional order in Uganda, and that those responsible for the abduction of Counsel Lukwago, regardless of the rank or office, be held to account according to law. This military intrusion into civilian space is patently illegal. The Constitution and the Uganda People's Defense Forces Act subordinate the armed forces to civilian authority and require them to remain neutral, professional, and bound by the rule of law. Soldiers have no business raiding civilian homes, abducting lawyers, or interfering in court processes. Such conduct inverts the constitutional order in which the military serves the people under democratic control and marks a dangerous militarization of governance. Lawyers are officers of the court, not agents of their clients' alleged conduct, and the Constitution entitles them to discharge their duties without fear, intimidation, harassment, or retaliation. Punishing counsel for fulfilling that role cripples the defense in high-profile political cases, corrodes the adversarial process, erodes public confidence in the judiciary, and violates the non-derogable right to a fair hearing under Article 28 of the Constitution and the corresponding international standards.
We therefore call upon the judiciary of Uganda, and especially the Chief Justice, Honorable Flavian Zeija, to break its silence over the abduction of and violence against its own officers. We further call upon regional, continental, and international human rights mechanisms, including the African Commission on Human and People's Rights, the East African Court of Justice, relevant African Union organs, and United Nations special procedures to intervene without delay and to discharge their mandates in the face of Uganda's escalating assault on the rule of law, fair trial rights, and the independence of the legal profession. Silence in the face of open military intimidation, unlawful detention, and threats against accused persons and their counsel amounts to neglect of mandate and a betrayal of the protection systems created to defend African peoples from precisely this kind of abuse. The lives, liberty, and dignity of Ugandans are sacred. They are not toys that a father can gift to a son. The rule of law must hold. Military neutrality and subordination to civilian authority are not negotiable. Uganda cannot become a state in which soldiers act as judge, jury, and executioner. The people of Uganda deserve justice, not intimidation. And every accused person deserves a fair hearing free from coercion, blatant bullying, and the most arrogant display of impunity. We who endorse this statement shall not relent. The abduction of one advocate, the imprisonment of another, and the death threats against a man already in custody will neither silence the African conscience nor weaken the demand for accountability. We stand with the defenders of the Ugandan Constitution and the rule of law. We further associate ourselves with the statements and position of Ugandan Law Society, the East African Law Society. Together, we shall pursue this impunity before every competent forum, at all levels, national, regional, continental, and international. Threats are not arguments, and barracks are not courts. The lives of Ugandans are not toys for President Museveni's son, Chief of Defense Forces Muhoozi to play with. He must be stopped.
People power, our power, our power, people power, people power, our power, our power, people power.